a reaffirmation agreement is simple. An individual filing a Chapter 7 bankruptcy petition is able to make a negotiation with a creditor that a debt incurred before the date the petition was filed will not be discharged as a result of the bankruptcy case.
This video covers the procedural requirements for filing a reaffirmation agreement, the legal requirements for a valid reaffirmation agreement, rescinding a reaffirmation agreement, advanced reaffirmation topics, and court actions on filed reaffirmation agreements.
Part 1. Procedural requirements for filing a reaffirmation agreement. 1A. Filing Chapter.
In practice, reaffirmation agreements pose numerous procedural hurdles, create difficult issues of legal representation, and require a precise navigation between legal procedures and the application of law, both of which must be tailored to the individual needs and circumstances of an individual filing a Chapter 7 bankruptcy case.
There are several different chapters under which an individual can file a bankruptcy petition. Chapter 7, 13, and sometimes 11, though 7 and 13 are most common. United States Bankruptcy Judge David L. Bissett will now explain why reaffirmation agreements are only filed under Chapter 7.
In Chapter 11 and 13, a debtor proposes a plan to repay creditors. Creditors are given specific treatment in the debtor's proposed plan. In Chapter 7, there is no repayment plan, so there must be a separate proceeding, a reaffirmation proceeding, to give special treatment to a particular creditor. Thus, reaffirmation agreements are only used in Chapter 7 cases.
Judge Bissett, you had said that individuals filing under a Chapter 7 bankruptcy petition can file a reaffirmation agreement, but can businesses filing under a Chapter 7 bankruptcy petition also file a reaffirmation agreement?
Businesses don't receive a bankruptcy discharge in Chapter 7. All the company's debts continue to exist after the bankruptcy case is concluded, so no need exists to file a reaffirmation agreement.
The statement of intention should be filed with the petition, but if it isn't, the debtor has 30 days after filing bankruptcy to submit it to the bankruptcy clerk. There is one exception, however, that requires the statement of intention to be filed sooner than 30 days. In every Chapter 7 case, the debtor has a scheduled meeting with the Chapter 7 trustee to review the debtor's financial circumstances. That meeting can take place as early as 21 days after filing the petition. When the meeting of the Chapter 7 trustee, commonly called the meeting of creditors, is held before the 30th day of the case, the statement of intention must be filed no later than the date of the meeting of creditors. Within 30 days after the meeting of creditors, the debtor must perform his or her intention, and the process must be completed before the debtor receives a Chapter 7 discharge, which, in most Chapter 7 cases, occurs 60 days after the meeting of creditors is held. Kelly Coder explains how a debtor performs his or her statement of intention.
When I'm meeting with clients, we discuss with them, do they want to keep their home? Do they want to keep their vehicles? There is a document that is included with the petition when the petition is filed, where the debtors indicate what they, if they want to retain the collateral and reaffirm the debt or surrender the collateral. So that document is filed with the court.
Is there an opportunity for the debtor to negotiate better terms with the creditor than existed before filing bankruptcy?
Typically, the reaffs have the same terms as the original loan document, so same interest rate, same monthly payment. But occasionally, in a situation maybe where a debtor isn't sure if they want to keep an asset, the creditor will kind of sweeten the pot and offer maybe knock down the interest rate, knock down the amount due. But generally, it's under the same terms as the original loan.
But what happens if a debtor does not file a statement of intention? We will now hear from a law student on this matter.
So a statement of intention is a mandatory court form. A failure to file a statement of intention may actually result in a deficiency notice being issued from the bankruptcy clerk's office. So if that happens, the case may be subject to administrative dismissal if the document isn't filed by the required deadline. A failure to state any intention regarding a secured debt has actual legal consequences. So, for example, the automatic stay that protects the debtor from the creditor collecting may automatically terminate, and then the creditor can then resume foreclosure, repossession, or any sale of the property.
Is the result the same if the debtor files a statement of intention but never undertakes any act to perform it, such as by sending the statement of intention to a secured creditor?
So not exactly. There is not a deficiency notice from the clerk's office once the statement of intention has been filed, but the result is actually the same. So, as we mentioned before, a debtor has 30 days after the meeting of the creditors to take action on the debtor's statement of intention. Failure to take any action then results in the automatic stay being terminated, and then the creditor being able to continue a foreclosure, repossession, or any other action against the collateral.
Although there is no official bankruptcy form for a reaffirmation agreement, the Director of the United States Courts developed two reaffirmation agreement forms, Form B 2400A/B Alt and Form B 2400. The main difference between the forms is that Form B 2400 includes the reaffirmation agreement itself, while Form B 2400A/B Alt allows a separate reaffirmation agreement to be attached. A reaffirmation agreement has many different required disclosures, and its content are highly regulated. Each reaffirmation agreement must be accompanied by Official Form 427, the cover sheet for reaffirmation agreements. Ryan Johnson, Clerk of the Bankruptcy Court for the Northern District of West Virginia, explains the purpose of the cover sheet and why it must be filed.
Official Form 427. The short answer is that the form must be used because it's an official bankruptcy form, and Rule 9009 requires that official bankruptcy forms be used. But there's actually a substantive reason for using Form 427, even though the form repeats almost all the same information that's already in the reaffirmation agreement, and it's this. When a debtor files a petition, the debtor files a schedule of income and expenses, Schedules I and J, and as the petition date, there may be some incentive for a debtor to provide a lower estimate of monthly income and a higher estimate of monthly expenses to avoid scrutiny for conversion, for abuse. Well, a reaffirmation agreement can be filed 100 days after the petition date, and it's natural there might be some changes to a debtor's income and expenses in the meantime. But on the reaffirmation agreement itself, there's actually the opposite incentive. There's an incentive to increase the estimate of the debtor's monthly income, decrease the estimate of the debtor's monthly expenses, because a negative budget on a reaffirmation agreement gives rise to a presumption of undue hardship, which requires court scrutiny, which requires additional work. The agreement may not be effective as it is filed. And so Form 427 provides this opportunity to disclose income and expenses as of the petition date and as of the reaffirmation agreement date, and if there's a difference, it provides an opportunity for the debtor to explain why this is, and so that the court can be informed whether or not there might be some untoward gamesmanship.
Part 2. Legal requirements for a valid reaffirmation agreement. The legal requirements to reaffirm a debt are contained in 11 U.S.C. Section 524. Subsection C contains the primary elements of a valid reaffirmation agreement, the first 4 of which concern all reaffirmation agreements, and the last 2 of which are special rules for debtors who execute a reaffirmation agreement without an attorney. We will explore the first 4 of these requirements in more detail. James Voigthofer, a career bankruptcy law clerk, explains what the first requirement means, that a reaffirmation agreement must be made before discharge.
The entry of discharge is largely an administrative process unless there is some factor preventing its entry. Discharge is typically entered 60 days from the date first set of the meeting of creditors. The meeting of creditors generally, in most cases, is set anywhere between 21 and 40 days after the petition date. So for the reaffirmation agreement to be made before the entry of discharge, the outer limit of that is generally no more than 100 days post-petition.
If a debtor is represented by an attorney, can the debtor waive this requirement and make a reaffirmation agreement after the discharge is entered?
The short answer to that is no. This idea and argument is based on the notion that a debtor represented by counsel in the reaffirmation process doesn't need the statutory protections provided by Section 524C. This was an issue before the bankruptcy court here in the Northern District of West Virginia in 2007 in the bankruptcy case of In re Cottrell. That was case number 06-819. And in that case, the debtor's attorney essentially argued that there were two different types of debtors in bankruptcy. Those that are able to understand the financial burden and consequences of their decision, and those that aren't. The debtor argued in that case, for instance, that the court should permit the waiver because the debtor was fully informed and knew of the consequences surrounding the waiver of the discharge. The Northern District of West Virginia, however, is located within the Fourth Circuit, and the Fourth Circuit in 1988 issued an opinion by the name of Arnold v. Kyrus. In that case, the Fourth Circuit determined that the provisions of Section 524C are to be strictly construed, including the filing of the agreement being before discharge.
What does the term made before entry of discharge mean? Obviously, it includes a reaffirmation agreement that is signed and filed before entry of discharge, but what about a reaffirmation agreement that is signed by both parties before discharge is entered, but not filed with the court until after entry of the discharge, or agreed to before discharge, but not signed or filed until after the discharge order is entered?
Notably, the code requires that the agreement be made before the entry of discharge. It does not require that the parties file the agreement before the entry of discharge for the agreement to be effective. And so if the parties come to a meeting of the minds, whether the agreement is fully executed or not, is what is determinative. The court will often look to general contract principles, if you will, to determine whether the agreement was made before the entry of discharge.
If the debtor and creditor are still negotiating a reaffirmation agreement when the discharge deadline is nearing, is there anything that they can do to delay entry of the discharge order?
Yes, but it's important that the debtor act timely. The entry of discharge and a motion to delay the entry of discharge is governed by Bankruptcy Rule 4004C2, and it specifically provides, quote, notwithstanding Rule 4004C1, on a motion of the debtor, the court may defer the entry of an order granting a discharge for 30 days. And on motion within that period, the court may defer entry of the order to a date certain. And so what's important is that the agreement be made before the entry of discharge. If the debtor and creditor are negotiating, it's important for the debtor to act timely to delay the entry of discharge so that the debtor can file the agreement before discharge.
If the debtor misses the deadline to make the reaffirmation agreement before entry of discharge, can the debtor ask the court to vacate the entry of the discharge order, file the completed reaffirmation agreement, and then ask the court to reinstate discharge?
This is a tactic that's been tried before, and it's generally been unsuccessful. To set aside the entry of a discharge order, the debtor would need to comply with substantive law and rules otherwise governing the reconsideration of orders. Generally speaking, missing a deadline to reaffirm a debt does not qualify under that substantive law and those rules.
The next requirement for a reaffirmation agreement is that all proper disclosures be made by the creditor to the debtor. How can both parties be sure that all the proper disclosures have been made?
Section 524 of the Bankruptcy Code contains many required disclosures for a reaffirmation agreement. Fortunately, the Director of the United States Courts has made 2 reaffirmation agreement forms available on the uscourts.gov website. These forms have all the required disclosures.
A reaffirmation agreement must be filed with the court to be valid. Obviously, a reaffirmation agreement filed with the bankruptcy clerk while the bankruptcy case is open is an agreement filed with the court. But what about when a case is closed? Can a bankruptcy case be reopened to file a reaffirmation agreement? And if so, if a bankruptcy case reopening fee is due?
A bankruptcy case is closed and somebody wants to come back to the bankruptcy court to reopen it to file a reaffirmation agreement. This is a giant red flag. It's a red flag because we already know that a reaffirmation agreement must be made before entry of discharge. A bankruptcy case, a Chapter 7 bankruptcy case, is not closed until after a discharge order is entered. Moreover, bankruptcy cases are only reopened under Section 350 of the Bankruptcy Code, and that section requires cause to reopen a bankruptcy case. And what cause exists to reopen a bankruptcy case to file a reaffirmation agreement that was not made before entry of discharge? The reaffirmation agreement is invalid. Where is the cause to reopen the bankruptcy case? And in many instances, a motion to reopen to file a reaffirmation agreement after entry of discharge is denied. However, if a debtor can show or wants to attempt to show to prove to the court that this reaffirmation agreement was actually made before entry of discharge through a meeting of the minds or through the paper record, cause has been found to reopen the bankruptcy case to allow this reaffirmation agreement proceeding to move forward. However, there is a catch. A motion to reopen is a fee event, and at the time of this video, the fee to reopen a Chapter 7 bankruptcy case is $260.
The fourth principal requirement of a reaffirmation agreement is that it is not rescinded. Jared Quinn, a bankruptcy law clerk in the Northern District of West Virginia, explains what rescission is and how an agreement can be rescinded.
Right, so the debtor has the right to rescind or annul any reaffirmation agreement within 60 days or before the order of discharge is granted. There's no formal process in order to necessarily rescind a reaffirmation agreement. However, at the minimum, a debtor should at least send a letter to the creditor stating that the debtor is rescinding the agreement. But the better practice, in fact, would be to make a record of the rescission, and if the notice is to be in writing and filed with the court, then the best practice may even be to format the notice in accordance with Section 342C of the Bankruptcy Code. And this notice should contain 3 things: the debtor's name, their address, and also the last 4 digits of their Social Security number. For an example of a properly formatted notice under Section 342C, I would see Official Form B420A. When an agreement is rescinded, case law states that any amount paid by the debtor to the creditor should be returned by the creditor. And this is in accordance with McCoffey versus GMAC Mortgage Corporation, in re McCoffey, 180 Bankruptcy Reporter 336, Bankruptcy Court of the District of Maine in 1995. In that case, the court scheduled a further hearing to determine the amount of which the creditor should have compensated the debtor for the actual use of the creditor's collateral before the reaffirmation agreement was rescinded.
Part 3. Advanced Reaffirmation Agreement Topics. Let's examine some more advanced reaffirmation agreement topics, such as the redemption alternative to reaffirmation, the existence of an installment redemption, and redemption financing, the ride-through alternative to reaffirmation for real property, and some of the pros and cons of making that election, the death of the ride-through alternative for debts secured by motor vehicles, the possible existence of a backdoor ride-through alternative to reaffirmation of a motor vehicle debt, whether an attorney representing a debtor is required to sign a reaffirmation agreement, or whether the attorney may permit a debtor to proceed pro se in the reaffirmation agreement process, Chapter 13 alternatives to reaffirmation, reaffirmation agreements, and automobile leases. 3A. Redemption alternatives. Martin P. Sheehan, an attorney in Wheeling, West Virginia, explains what a redemption is and how it could be an alternative option to a reaffirmation for a debtor in a Chapter 7 bankruptcy case.
When I explain redemption to a client, what I normally say is that it's a process where you buy a vehicle, but you buy a piece of secured property back from a secured creditor at the current value of the property.
Can you please explain what this would look like in a real case?
Historically, we talked about refrigerators. Some time ago, people would go to Sears, they'd buy a refrigerator, it would be, they'd finance it over time, and then they'd take it home, they'd scratch it, they'd dent it, they'd put onions in it. It wouldn't be worth exactly what they owed Sears. If you let Sears take the property back because it hasn't been paid for, you might be able to go up to the store, find your model on the floor, and then buy it back. The only person who makes money in that process is the fellow with the truck who's driving the refrigerator back and forth to Sears. As bankruptcy lawyers, we're somewhat smarter than that. So, because a secured creditor typically can repossess the collateral, the value to them is the value of the collateral. So if you can agree on what the value of the collateral is and agree to pay them, then you can keep the collateral. And that's, in this case, the refrigerator. Examples sort of are a little better. If you buy a fridge at $1,000, you finance it over time, and then it's currently worth $600, but you owe $750. If you can pay the $600 now, then what you're able to do is to repossess, is to keep the collateral without having to lose it. That's sometimes a useful option. We tend to talk about smaller items like refrigerators or other small pieces of collateral because a debtor has to buy it back at probably about 60 days into the bankruptcy case. If you ask them to save money so that they can afford to do the refinancing, they can do that pretty quickly. If you ask them to do a car, it's much more difficult. Legally, it's the same. You can redeem a car. It's just that if you ask people to finance, to save up the cash pretty quickly, that's hard to do.
Do you have an example of any past experience you've had with redemptions?
I did have a case where I had a client who redeemed a car for $5,000. Her mother gave her the money to do that. The car was underwater for about she owed about $10,000. So redemption turned out to be a very successful approach to her. Sometimes in a Chapter 13 case, you can extend the period of time to pay for redemption, and the option to redeem a car in a Chapter 13 case is a little bit easier.
Reaffirmation agreements are most often filed to reaffirm debts on real property or automobiles. With real property, there's another alternative called retain and pay. To make this election, a debtor must check the box on the statement of intention, retain the property, and explain. Here, the example would be on a line saying retain and pay according to contract. The Honorable David L. Bissett will now explain how the retain and pay option came into existence.
In 1992, the Court of Appeals for the Fourth Circuit decided in Ray Ballinger, cited at 962 Fed 2nd 345. The court reviewed Section 521A2 of the Bankruptcy Code and saw that a debtor was to either redeem, surrender, or reaffirm, securing a loan if applicable. The court reasoned that in a case where redemption, surrender, or reaffirmation were not applicable, no election had to be made by the debtor. The court further reasoned that the Bankruptcy Code prohibited contractual clauses that declared that the contract breached if a debtor filed bankruptcy, commonly known as ipso facto clauses. This is important because in circumstances where there is no breach of the underlying contract, for example, the debtor were current on the debtor's contractual payments when the debtor filed bankruptcy, then there could be no default under the contract by the happenstance of a bankruptcy filing. In these circumstances, the court reasoned no default existed to cure by executing a reaffirmation agreement. Instead, the debtor and creditor could merely continue their pre-petition relationship. The one important exception was that once the debtor obtained a Chapter 7 bankruptcy discharge, the debtor's personal liability under the underlying note was discharged. Of course, if a debtor wants to keep the collateral, the debtor must continue to make the contractual payments to the creditor. However, should the debtor later default on the contract, the creditor would have the right to repossess or foreclose on the collateral, but the debtor would not be liable for any deficiency judgment. So based on the probability of future default, a debtor is likely better off maintaining the contract and making specific periodic payments, which would likely be the same result under the Reaffirmation Agreement.
Often, a mortgage on a home property can last 20 to 30 years after the date the petition for bankruptcy is filed. Refinancing a home mortgage is a popular way that many people obtain cash for things such as financing their children's education or for home improvement projects. David Hinkle, an attorney in Martinsburg, West Virginia, explains to us how he advises his clients regarding the retain and pay option of a real property ride-through.
The primary consideration, obviously, that we look at is what our clients want to accomplish after the bankruptcy, right? So obviously, we're going to first and foremost look at their financial situation to see whether a reaffirmation is risky for them. That's really what it comes down to. And there's different schools of thought on how to handle the pay and retain or the ride through with real estate. I've talked to attorneys all over the country. It seems like different jurisdictions have their own way of handling that. I would say now in our practice, most everyone, if they have a home that they're wanting to keep, chooses to reaffirm. For most of my clients, it's a very low risk way to retain a relationship with a lender, to get credit, to help them sort of accelerate that fresh start in terms of getting the credit reporting. And for most people, the purchase of a home is one of their biggest investments. It may be the biggest investment that they're ever going to make. The flip side to that is, most folks who come to see us for assistance with bankruptcy they don't intend to come see us. They don't plan it. They want to come out of the process with as little harmful side effects as possible. And one of the ways to do that is to reaffirm the house. And so by reaffirming the house, it's a relatively low risk way to continue to build your credit, to have a payment history that's readily available for other lenders. And most of my clients come into the process not really understanding the intricacies of reaffirmations, but they're very clear that they don't want the bankruptcy to affect their home or their mortgage. And most of the time, our clients choose to do a reaffirmation when considering the whole picture with regard to not just the advantage of the discharge, but to what things are going to look like with regard to their financial situation maybe 3, 4, 5 years down the road.
Following the decision by the Court of Appeals for the Fourth Circuit in 1992, debtors in bankruptcy were frequently utilizing the retain and pay option for both real property and automobiles. However, in 2005, a change in the law sought to eliminate the ride-through option for automobiles. Ryan Johnson, clerk of the Bankruptcy Court for the Northern District of West Virginia, explains what this change was and how it impacted the retain and pay option for automobiles.
The death of the motor vehicle ride-through in bankruptcy. This explanation can be a little complicated, but we're going to make it crystal clear. We start with two provisions of the Bankruptcy Code, Section 365E, Section 541C, that prohibit ipso facto clauses. Ipso facto clause is a term in the underlying consumer loan contract that puts a debtor in default of the contract by the mere happenstance of bankruptcy. These two Bankruptcy Code provisions prohibit that from being an event of default. But nonetheless, this term is in almost all underlying consumer loan contracts for purchases of motor vehicles. And then, as Judge Bissett previously told us, the Fourth Circuit in 1992 said there's a retain and pay option available for motor vehicles. If a debtor is current on payments when they file bankruptcy, these two bankruptcy code provisions prohibit a non-monetary default for filing bankruptcy. Redeem, reaffirm, or surrender are not applicable provisions. The debtor can continue to retain this vehicle and pay for it pursuant to the contract and shed the debtor's personal liability. But in 2005, this law changed. There was an additional paragraph added to the Bankruptcy Code, to Section 521, that made the debtor's right to redeem, reaffirm, or surrender a motor vehicle subject to Section 362H. Section 362H says if a debtor fails to indicate on their statement of intention that they will redeem or reaffirm a motor vehicle or surrender, then the automatic stay lifts and the property is no longer property of the bankruptcy estate. Now, from the debtor's perspective, this isn't so bad because the debtor's current on payments. There's two provisions in the Bankruptcy Code that prohibit the effect of ipso facto clauses, and property being property of the estate, that affects more the trustee than the debtor. However, there's another provision of the Bankruptcy Code, Section 521D, which references 362H. And it says, for a motor vehicle, if the debtor fails to indicate on the statement of intention, redeem, reaffirm, or surrender, then these ipso facto provisions become effective. So even though the debtor is current on payments, if they didn't indicate redeem, reaffirm, or surrender on the statement of intention, the automatic stay lifts, the property is no longer property of the estate, and these underlying contractual ipso facto provisions are effective. And this is the death of the motor vehicle ride-through in bankruptcy. However, as a debtor's attorney, you might think, well, what about state law? My client has to be in default under state law. There's an opportunity to cure a defect under state law. Can the creditor continue to repossess under state law? And in the Fourth Circuit, as of this moment, the answer is yes, because bankruptcy is a non-monetary default under a contract, and there is no right to cure a non-monetary default.
After the 2005 changes to the Bankruptcy Code, debtors were no longer able to choose the retain and pay option, but had to choose either to reaffirm, redeem, or surrender the collateral. Is there any other way in which a debtor can keep the collateral without executing a reaffirmation agreement?
Okay, we've covered the death of the retain and pay, the ride-through option for motor vehicles in bankruptcy. There are actually two exceptions to this rule. One is legal, the other is practical, and I will cover the legal exception, and the attorney will cover the practical exception. The legal exception is the backdoor ride-through. A debtor must indicate on the statement of intention that the debtor intends to reaffirm the debt. The debtor must mail the statement of intention to the creditor. The debtor must sign the reaffirmation agreement, and the reaffirmation agreement must be filed with the court. And so in this instance, the debtor has complied with the statute. The debtor has done everything that the debtor is supposed to do. But not every reaffirmation agreement is effective as filed. Some reaffirmation agreements must be scrutinized by the court. And what would happen if the court were to disapprove or deny a reaffirmation agreement? This is what happens based on case law. The automatic stay remains in place, the property remains property of the estate, and the prohibition on ipso facto clauses remains in place. It puts the debtor in the exact same position that the debtor was before 2005 when this change in the law occurred. The debtor now has the opportunity to retain and pay for a motor vehicle without executing the reaffirmation agreement, or I should say, without a valid reaffirmation agreement being in place. And so if you're an attorney representing the client, how are you going to accomplish this? How are you going to convince the court to deny this reaffirmation agreement? And this is where court actions on reaffirmation agreements become very important, because you want to know when a court might scrutinize a reaffirmation agreement and when a court might deny it, and under what circumstances would a court deny a reaffirmation agreement or not approve it. And that will be covered a little later in this video.
The second method to a retain and pay for an automobile without executing a reaffirmation agreement is based on practice and business savvy. Todd Johnson, an attorney in Morgantown, West Virginia, explains his approach to the eat steal mentality that may be a second way for a debtor to retain and pay for an automobile without executing a reaffirmation agreement.
Well, eat steal, not really language that I use. And fortunately, my clients they're not often forced to reaffirm debt. If they get a reaffirmation for a home mortgage, there's no obligation for them to sign it, and they just keep making their mortgage payment. They get to keep their home. And probably about 9 times out of 10 with a vehicle loan, if they get a reaffirmation agreement, creditor doesn't force them to sign that either. So again, they get to let the debt get discharged, and they continue to make voluntary payments and keep the vehicle, which is ideal for me, because then later on, you never know what the future is going to hold. If they no longer want to make payments or can't afford to make payments, they could simply let the collateral go, normally the vehicle, and then they won't owe any more money, and there's no further damage to their credit, which is perfect. But it's a very rare situation, again, maybe 1 out of 10 for car loan creditors, that they actually say if they want to keep the vehicle, then they have to reaffirm. And that puts them in a tough position.
It seems intuitive that an individual is represented by an attorney when an individual hires an attorney to file a bankruptcy case. And when a debtor is represented, the reaffirmation agreement has a specific place for the attorney's signature. Notice, however, the language of the certification required by counsel, which, in turn, is required by Section 524C3 of the Bankruptcy Code. Obviously, making these certifications puts counsel in the odd position of adjudicating, rather than advocating, a client's ability to make the requested reaffirmation agreement payments. As one bankruptcy judge expressed it, attorney declarations reflect a contradiction in role that is, in this court's view, unique in the law. After giving appropriate advice to the debtor's counsel is expected by Section 524C3 to take his or her client's instruction as to reaffirmation and then effectively decide whether to assent to or veto that decision. This court cannot recall another scenario in which an attorney and advocate is so blatantly asked to judge his or her client's actions.
So when a debtor is represented by an attorney, is it possible for the attorney to separate his or her viewpoints on the debtor in the bankruptcy case versus with a reaffirmation agreement? J.J. Voigthofer explains different points of view on this topic.
The short answer to that question is that it's best to know local practice. This topic really presents two related issues. The first being whether counsel is permitted to unbundle services, that is, represent a debtor for some things in a bankruptcy, but not all things, including the reaffirmation agreement process. And then related to that is what effect the debtor's counsel not signing the agreement has on the agreement. For example, the bankruptcy court for the Northern District of Oklahoma in Ray Minardi said that the decision to reaffirm an otherwise dischargeable debt plays a critical role in the bankruptcy process, so critical that assistance with the decision must be counted among the necessary services that make up competent representation of a Chapter 7 debtor. Second, the code lays the responsibility for advising a debtor about the reaffirmation process and evaluating the effect of each agreement at the feet of debtor's counsel. The court will not relieve counsel of this responsibility. That is generally the practice also followed in the Northern District of West Virginia. However, an issue is created when counsel represents the debtor in negotiating the reaffirmation agreement, but chooses to not sign the agreement because counsel cannot certify that the agreement does not constitute a financial hardship for the debtor. At least one court in the Eastern District of North Carolina in Ray Bowden held that in the future, when an attorney refuses to sign a client's reaffirmation agreement, a hearing will not be set. the agreement is unenforceable on its face, judicial action is not warranted, and a hearing would therefore serve no legitimate purpose. And that's at 2012 Bankruptcy Lexus 627. Locally, however, the court will treat a debtor in that context as being pro se and still hold a hearing. For instance, in the case of In re Wilson, it's 2012 Bankruptcy Lexus 2896, a June 26, 2012 decision by Judge Flatley. He held a hearing for a debtor who sought to reaffirm debt secured by an automobile. The debtor was represented by counsel, but counsel chose to not sign the agreement. At the hearing, debtor's counsel urged the court to not approve the reaffirmation agreement, but instead permit the debtor to keep the vehicle by what is known as a backdoor ride-through. In that case, the court allowed the debtor's attorney to refuse to sign the reaffirmation agreement and allowed the debtor to proceed pro se for that limited purpose. As I said at the outset, it's best to know local practice until this issue is resolved by appellate courts.
3F. Chapter 13 Alternatives to Filing a Reaffirmation Agreement. Sometimes a debtor is insistent on filing a reaffirmation agreement, whether it be to fulfill a contractual payment to a creditor, to even help raise their credit score, or to make it a possibility for a future loan to be taken out with the same creditor as they did pre-petition.
Megan Priest, an attorney to the Chapter 13 trustee for the state of West Virginia, explains why Chapter 13 may be a good alternative for a debtor who is contemplating filing a Chapter 7 petition and desires to execute one or more reaffirmation agreements.
I am a Chapter 13 trustee employee, so of course I'm going to be a little biased about this. But I think that Chapter 13's, if you're going to do reaffirmation agreement, a Chapter 13 is going to be better for you. With a Chapter 13, the control of how a claim is paid is going to be in the debtor's hands. So with a reaffirmation agreement, really the creditor has all the power there. Sometimes they'll give you a lower interest rate. Sometimes they'll put any default at the end of a plan or at the end of payments, or extend it out. But for the most part, they have all the control. They're the ones who decide what happens. However, with Chapter 13, you can lower interest rates as long as you meet certain requirements. You can get that down to basically a prime rate plus 1 to 3%. So that's a lot lower than most interest rates that I see, which are anywhere from 17% to 25%. So that's something that's really good. It's also, you're able to extend it out throughout the life of the plan. Most plans run anywhere from 3 to 5 years. So that's going to be a lower payment for you on anything that you're going to reaffirm. It's really good because it puts all the control in you, and it's the creditor who has to object to it, and they actually have to have standing to object to it.
A frequent question that arises concerns reaffirmation agreements and automobile leases. Can or should a debtor who wants to maintain personal liability on an automobile lease file a reaffirmation agreement? Jared Quinn, a bankruptcy law clerk in the Northern District of West Virginia, explains the difference between leases and secured debt in the bankruptcy context.
A lease vehicle assumed pursuant to Section 365P of the Bankruptcy Code, and that section has its own procedures that are separate from the reaffirmation process. A legal issue exists regarding whether a reaffirmation agreement is required to impose personal liability on the debtor should the debtor later default on their payments. Shown here are a few cases that have held that a debtor does not assume personal liability on an assumed lease under Section 365P unless the debtor also executes a reaffirmation agreement. Cases that show no personal liability absent a reaffirmation agreement include Thompson versus Credit Union Finance Group, a 453 Bankruptcy Reporter 823 of the Western District of Michigan in 2011 state that lease assumption agreements under Section 365P do not preserve personal liability for discharge debt absent compliance with reaffirmation requirements. Also in re Reader, a 426 Bankruptcy Reporter 164, Bankruptcy Court District of Maryland in 2010 also state that lease assumption agreements under 365P do not preserve personal liability for discharged debt absent compliance with the reaffirmation requirements. And the same holds true for In re Rogers at 359, Bankruptcy Reporter 591 of Bankruptcy Court of the District of South Carolina in 2007. Other cases, though, have reached different conclusions. Personal liability and assumption cases such as Bobka versus Toyota Motor Corporation in 586 Bankruptcy Reporter 470 of the Southern District of California in 2018 state that assumption of a lease under Section 365P means that the debtor remains personally liable on the lease and if there is no need for reaffirmation.
What about the Northern District of West Virginia? How has the court adjudicated this question in other cases?
Well, the court has not issued a written opinion. The court's practice has been to encourage parties to enter into a stipulation and an agreed order under Section 365P rather than filing a reaffirmation agreement with the court.
Part 4. Court actions on reaffirmation agreements.
Already, we've covered different reaffirmation agreement procedures, forms, requirements, some advanced topics, and some alternatives to filing a reaffirmation agreement. We will now hear from the Clerk of Court, Ryan Johnson, on the court's action when filing a reaffirmation agreement and what is required from the court when a reaffirmation agreement is filed.
To determine which reaffirmation agreements are effective as filed and which require further court action, the Northern District of West Virginia has computerized the process, and so long as an individual inserts truthful information, our program will inform a party immediately whether or not the agreement is effective as filed or whether further court action is required.
In reviewing reaffirmation agreements, it is important to note that every pro se reaffirmation agreement requires the court to, at a minimum, inform the debtor that 1. The agreement is not required by the bankruptcy code under non-bankruptcy law or under any agreement that was not made in accordance with the rules governing reaffirmation agreements, and 2. Of the legal effect and consequences of the agreement and default under the agreement. Let's listen to Bankruptcy Judge David L. Bissett give these admonitions to a pro se debtor.
Go over some of the requirements of entering into a reaffirmation agreement, and so you understand what rights you're waiving as a result of that. And we'll do that at this point, and I'll ask you to positively affirm or answer the questions I'm going to state to you. Both of you, if you would do that for me when I read the question, if you do in fact agree with it. And the first question I have for you is you are not required under the bankruptcy code or any non-bankruptcy law to enter into these agreements with the creditor. Do you understand that?
Yeah. Yeah.
Okay. The creditor cannot force you to enter into any such agreements, but you may do so voluntarily. Do you understand that?
Yeah. Yeah.
It is your wish to voluntarily enter into such agreements with the creditors. Is that correct?
Yeah. Yep.
Okay. The discharge which you will receive or have received discharges you from any personal liability on these debts should you default in the future. Do you understand that?
Yeah. Yep.
And by reaffirming these debts, if you default and the collateral is sold at auction or otherwise, you agree to be personally liable for any deficiency on this debt if the sale of the collateral is not sufficient to satisfy the debt owed. Do you understand that?
Yeah.
Okay.
When the debtor is pro se, are there other requirements for the court?
For items such as motor vehicles, but not most consumer home mortgages, the court must make a determination that the agreement does not impose an undue hardship on the debtor or a dependent of the debtor, and that the agreement is in the best interest of the debtor.
There are actually 2 undue hardship tests for reaffirmation agreements in the bankruptcy code, right?
Exactly. The undue hardship test we just spoke about concerns the totality of the debtor's circumstances. There is a second undue hardship test, which is actually a presumption, and it applies whenever the debtor's income is less than the debtor's monthly expenses. And to make matters more confusing, it applies whether or not the debtor is represented by an attorney. It only applies for a 60-day period, and it does not apply in a case where the creditor is a credit union. Confusing? Absolutely. There's an article in the American Bankruptcy Law Journal that helps explain when court action is required on a reaffirmation agreement. This chart is particularly important when an attorney would like to attempt a backdoor ride-through because it provides insight on how a court might deny a reaffirmation agreement. Let's look at an example. In this case, the debtor disclosed income of $2,500 in pension and unemployment benefits and claimed expenses of $3,463 for a monthly negative budget of $963, which includes the debt sought to be reaffirmed, a $400 monthly payment on an automobile having a value of $4,700. If you were the bankruptcy judge in this situation, do you think that the debtor has sufficiently rebutted the presumption of undue hardship?
We hope that you found this video on reaffirmation agreements informative. If you are pro se and thinking about filing, please note that you are allowed to represent yourself in a bankruptcy court case. However, as this video illustrates, even a small facet of bankruptcy can become very complicated very quickly. At a minimum, we recommend consulting with legal counsel before you file.
If you are an attorney, paralegal, or other law office staff, we hope that you found this video informative. If you have further questions about reaffirmation agreements and the reaffirmation agreement process, please reach out to an attorney practicing bankruptcy in your area. If you have questions about court processes and procedures, you may call the bankruptcy clerk's office or post your question on the bankruptcy attorney lister for West Virginia. Thank you for watching.